Hi, it's Roland Jones. Thanks for watching. This is a short video on a recent bankruptcy case having to do with preferences or clawbacks, part of the series I'm doing of short videos. This is a very recent case, Garner versus Knoll. It's a Fifth Circuit case from the great state of Texas. It's an interesting case about an extremely persistent trustee and a secured creditor extremely reluctant to return a payment made to it during the 90-day preference period. The facts of the case are as follows. This is a retail furniture dealer, borrowed funds from a creditor called Textron. Part of the agreement was that Textron would have security interest in all the debtor's receivables. The debtor put all its money into a lockbox, including the account receivables, and the lender would scoop out the money to pay the debtor's debt to the lender. And this happened as well during the preference period. Trustee was appointed after the company went bankrupt and sued the lender for a preference, since these payments were made to the lender during the preference period. And various arguments were made by the trustee and the lender. The lender says, well, these are payments of my own collateral. You can't demand that these be returned. These aren't preferential, because these payments would not have reduced the amount available to other creditors in a hypothetical bankruptcy case. That's the whole point of the preference laws, is to protect other creditors and make sure one creditor is not paid more than it would have been if a bankruptcy Chapter 7 case were filed immediately at the time of the transfer. So the lender says, hey, we would have paid this money anyway. Why? Because it's our money. It's our collateral. It's coming out of our collateral. It's account receivables. Trustee argued, well, they took some of the money out of the lockbox, and maybe some of the money was theirs, but what was left over wasn't theirs, and it wasn't their collateral. And so what was paid to them is arguably not their collateral. So this is the applicable code section that's in dispute. The trustee has a burden of proving the elements of 547B, and this is 547B5. So the theory is that if a creditor had not been paid more by the transfer than it would have been paid in a hypothetical Chapter 7 case, then the transfer should not be avoided. Why? Because it would have been paid the same in a bankruptcy case or outside a bankruptcy case, and so other creditors are not affected. It's not getting more. It's not getting a higher percentage. So it's not unfair to other creditors. This is known as the hypothetical Chapter 7 liquidation analysis that's typically done by the courts. But in this case, the court cited sort of a shortcut around that. The court applied the abbreviated El Paso refinery analysis, which is derived from a 1999 Fifth Circuit case. The El Paso analysis basically says that if the transfer reduced the creditor's collateral or was made from the creditor's collateral, then the trustee is not going to be able to establish that that creditor received more or would have received more under a hypothetical Chapter 7 bankruptcy case. The court found that this was indeed the case here after looking at some Texas state law on the nature of the creditor's security interests in the funds in the lockbox, and found that indeed that the funds did come from the collateral and reduce that collateral, and therefore this was not a preference, and the lender prevailed. In the case, the United States Court of Appeals affirmed the bankruptcy court and the district court decision.